Okay. So the first case on my docket then is Trayvon Davis.
Yes, Judge Kelsey Moldoff from the Office of the Public Defender on his behalf. He is present in the back row in the khaki.
Okay. So let me hear from the state.
Hi, Allison Graber on behalf of the state. The juvenile scores 19 points. We're asking for a 21-day secure detention and no victim contact.
From the department.
Judge, I have no legal objection at this time. I would just ask if Your Honor would consider allowing whoever his regular division judges to review your detention status. Nobody is present today for Mr. Davis. In the event stepfather wants to come in or mom and get some additional information about this, just based on the nature of the charges, I would just ask that Your Honor permit whoever the division judges to review your detention status.
Cer-
Judge Orlando.
Certainly, they can review it at any time. I mean, I'm gonna,
I just need the detention order to indicate it.
Okay.
As long as that's okay.
so I have a detention order? Okay, I'm gonna securely, enter an order to securely detain him. But it can reflect that Judge Orlando can take a look at it if anybody else has any
Thank
other
you.
information.
I appreciate it, Judge.
Do I need to reflect that on this order?
I wrote it on the bottom, Judge. Yep.
Okay, got it. You take this paperwork too?
Yes.
Okay. Next, we have Jerome Hines.
Yes, Judge. Jerome Hines is present. He just stood up for Your Honor.
Okay,
Kelsey Moldoff from the Office of the Public Defender on his behalf. Oh, and also for the record, Mr. Davis has filled out a public defender application this morning on the new case.
okay. And has that been reviewed or?
Yes, and he was found indigent.
Okay,
So Mr. Hines is here on 19-3628 and a new law of 19-3767. I'm already his public defender on 19-3628, but we're asking that we be appointed on 19-3767 this morning.
and did he fill out an application on that
He
one?
did, Judge.
And does he appear to qualify?
He does.
Okay,
Thank you.
I'll appoint the Public Defender's Office on that case then. And let me hear from the state with regard to this.
The state's, he scores 15 points and the state's asking for 21 days secure detention.
Okay, do you have anything?
But
So-
unfortunately, I have no legal objection at this time.
Okay, I'm gonna enter an order securely detaining him at this time for 21 days.
Good morning, Judge.
Morning. So would that be as to both cases, right? The new case and the
Yes, Judge.
other case is he on supervised release, is that?
Yes, he was on EM.
Okay.
in that training environment. Yes.
As a probation or as a
As home, as supervised release.
supervised release? Okay. So then we need to enter the order as to both of the cases. Okay. Okay. We are on the record, and we are here this morning for first appearance hearing. I'm going to start by calling a couple of the attorneys that have signed. And Mr. Shate, step out. Mr. Coffey? Good morning.
See you.
Too. Here on Richard Calixte.
Yes, Your Honor. He's on page 11 of the magistrate docket.
Okay.
Judge, I have the
Where
alleged.
is he? Which facility? Okay. Is that the main jail? Is that Mr. Calixte? Can you hear us? Okay, Mr. Calixte?
Yes, Your Honor.
Okay, you're here this morning for a first appearance. The charge is battery, causing bodily harm, domestic violence. I do find probable cause for that offense. Your attorney is present here in court. Can you see him?
Yes.
Okay. I'll hear from the state first with regard to bond.
The state would be, his name is Joseph, on behalf of the state will be requesting $1,000 bond with no victim contact,
With what?
no victim contact.
Okay.
Judge, I have the alleged victim here. She would like contact. She's the one who hired me this morning.
You raise your right hand. You swear or affirm to tell me the truth? Could you state your full name for me? Pardon?
Speak up a little bit.
Okay. You can put your hand down. How are you related to Mr. Kellick? Okay. And your attorneys indicate, his attorney's indicating that you want to have contact with him. Mr. Coffey, I'll hear from you, but
Thank you.
based on the allegations, I'm inclined not to have him have contact right now. What says you with regard to that?
Ma'am, are you afraid of your husband? No. Has anything ever like this alleged incident ever happened in the past? No. Is anyone forcing you or threatening you to come here today to court to tell the judge that you want contact? No. Do you have any children together?
Yes, we do.
How many children do you have?
We have 2 children together.
Okay. If the judge were not to allow contact, if she were to say you can't have any contact during this time period, would that be a hardship on you all financially?
Definitely.
And can you explain to the court why?
Well, he would do anything at the house so we can
Does he help with the child raising?
Yes.
Okay. Are you working?
Yes.
And so between the two of you, you're able to watch the children, but do you have any other help besides that?
No.
Okay. So it would be a tremendous hardship to you if you weren't able to have contact during the time, I guess, pre-filing or before the charges get filed.
Yes, we do.
Okay. Judge, I don't have any other questions.
State, do you have any priors?
I see no Florida priors, Your Honor, but as far as no contact, the incident occurred yesterday. The state would just be requesting no contact just for a cooling off period, Your Honor.
Pardon? I can't, you have to speak up.
The state will be requesting no contact. The incident occurred yesterday, so the reason for the no contact is for a cooling off period, Your Honor.
Judge, he's saying a cooling off period, like so, and you're saying you want no contact
My
just for a
con-
limited time?
Mr. Coffey, I'll tell you the
Yes, sir.
concern the court has.
Yes, Your Honor.
It's one of the children called 911.
I read that, Judge.
So that's my concern. You know, if it was 2 adults living in a house alone, I understand the state's position that cooling off period, maybe cooler heads would prevail and now they move on. But the fact that there's children involved concerns the court. So,
Judge, again, he has no priors, which is kind of rare in a lot of my cases anyway. So with that, like I said, this seems to be an isolated situation. I don't expect the case to go very far. As this court knows, these types of cases tend to naturally go away. I just would hope, I'm just asking the court for the next few weeks while I work the case, preliminary during pre-filing, the court would give them that opportunity to stay together.
set bond in the amount of $1,000. And I will allow contact based on this order here. I don't need to sign this then, is that right? This no contact order? I'm allowing contact. Okay, I'm just gonna, all right.
Thank you, Judge. Appreciate it. Have a great day. Happy holidays.
Okay, when Mr. Shake gets here, just let me know. I also do have some people here on behalf. Looks like, can we call out of turn? Ashley Yarnell Harrison. Where's Miss, where?
I'll check to see where she is. Your Honor, also, if I could be heard before the court makes a finding.
Sure.
please.
Where's Miss Harrison? Paul Ryan, thank you. Ashley Yarnell Harrison.
Who you looking for, Your Honor?
Harrison?
Harrison?
Yes.
She's on her way.
Okay. Miss Harrison, please?
I think she's might be walking in
Oh, okay, I
now.
thought that was them then.
Excuse me, Your Honor. Jackson is here on Paul Ryan.
Okay, is this Ashley Yarnell Harrison?
Yes, ma'am.
Okay. Let me hear, you're here this morning charged with a writ of arrest, and it looks like in the amount of $292. A capias for a criminal traffic case from 2014. Robbery by sudden snatching with a firearm or weapon and committing a first-degree felony with a stolen law enforcement officer firearm. Let me hear from the state.
Your Honor, all right, first off, on count 3, that charge was misbooked. I would direct the court's attention to the warrant, where she was charged robbery with a firearm, 812.132A. She was booked accidentally under 812.131.2A. So this should be a robbery firearm punishable by life offense.
Okay,
Your Honor, on that count, the state would be seeking a finding of proof evident or presumption great for first appearance purposes and requests that Ms. Harrison be held no bond so that the defense, if they so choose, can file for an Arthur hearing. The state would be relying upon the arrest warrant affidavit prepared by Detective Stephen Hoover of the Broward Sheriff's Office. Your Honor, now I understand that Judge Siegel found probable cause on count 4. Based on my review of the warrant affidavit, I would not have an objection to an ROR. I spoke to Detective Hoover. There might have been a little confusion about, possession of firearm by a convicted felon. I don't see any prior felony convictions, so that's why I'm okay with an ROR.
okay. I don't know if Judge Siegel found probable cause as to that. He issued an arrest warrant based on that, so I don't know.
And by definition, he would have found probable cause by signing it. That's why I'm not asking the court to find no probable cause, but just
Okay,
essentially at the end of the day, make it an ROR.
okay. I'll hear, could you please put your name on the record that's here on her behalf?
Yes, my name is James Harrison.
Okay, and how are you related?
I'm her father.
Okay, thank you. And you?
My name is James Harrison, my brother.
Okay, thank you for being here. Okay, want to hear anything from the defense?
Yes, Judge, we would ask the court not to make a finding of proof evident presumption great at this time. It's the highest standard of proof that we have in the criminal justice system. I have reviewed the affidavit in the case provided to me by the state. I really can't make a good faith argument that count 3 is not actually a robbery with a firearm. I think that the language in the affidavit supports that charge. And probable cause is one thing, proof beyond a reasonable doubt is certainly something else. The state has not introduced any evidence, called any witnesses to support the contention that this court should make a finding of such a high legal standard, so we would ask the court not to make that finding of proof evident presumption great at this time. In the alternative, if over our objection the court does make a finding of proof evident presumption great, we would encourage the court to exercise its discretion and set bond for Ms. Harrison. Obviously, she has some strong family support here in the courtroom today. Both her father and her brother have been sitting here all morning and are very, very supportive of her. So in light of that, if her prior record, which I'm not really clear on what exactly her prior record might be, but if it's not too bad, I would ask the court to set bond.
Your Honor, she has no record. That being said, at this point in time, for first appearance purposes, the allegations being that she brought a firearm into a business, threatened the employee with the firearm if the employee did not comply and open the register and give her cash. I do think it's dangerous enough that an Arthur hearing would be appropriate where the alleged victim, if she so chooses, under Marcy's law, could have an opportunity to address the court. Additionally, as the court, I know the court is aware, the Fourth ECA under the lineage of cases Isaza and Brackett have ruled that the state may properly rely upon affidavits in supporting proof evident or presumption great at a bond hearing. I would note that there is surveillance video of the incident corroborating the victim's version of events, and after being given a double-blind photo array, the victim identified Ms. Harrison with 100% certainty.
And if I just may, Judge, all the more reason why that evidence should have been presented to the court this morning.
Okay, so I have read the arrest warrant and the accompanying affidavit that Judge Siegel signed, and I do find that there is proof evident presumption great as to the robbery with a firearm. That robbery, I'm going to change it on the arrest sheet here that it is with a firearm. That being said, she will be held no bond until she sees the judge who's actually going to be handling her case, and the attorney that's representing her can actually file a motion before the judge who's handling her case. So for purposes of this morning, I will set no bond on that charge. As to the count 4, I'm going to ROR her based on that. She's also got a $292 writ of arrest and a capias or a warrant for a 2014 case. So you will be able to be in touch with the public defender's office about her having a hearing with the judge whose case she's going to be before. Okay? Thank you for being here, though. Mr. Shate, you want to? Well, I have one with some family members. You mind if I call that first?
That's fine, Judge. No,
Okay.
of course.
I have one here. Tyrone Richard Bell. Domain? Mr. Tyrone Richard Bell?
Major.
Okay, good morning. Mr. Bell, you're here this morning. You're charged with aggravated child abuse, battery causing bodily harm, domestic violence, throwing a missile into a dwelling or vehicle, and probation violation or community control on a felony case for looks like Judge F.K. Could you say who your names that are here? Would you mind saying your names on the record?
Alexis Sharp and Tykira Bill.
I can hear you.
Tykira Bill. Alexis Sharp.
Okay. And how are you related to Mr. Bell?
I'm his wife. I'm his daughter.
Okay. Thank you for being here this morning. What says the state with regard to the charge and the bond?
Your Honor, on count 1, I'm going to be requesting a $2,500 bond, taking into consideration the allegations and the age of the alleged victim. On count 2, $1,500 bond, and a $2,500 bond on count 3. Total bond is $6,500, also in consideration of the no bond hold on count 4. Your Honor, I would also be requesting no victim contact at this time.
Mr. Reedy? You want to be heard?
Barbarak may have some further
Oh,
information,
okay.
Judge.
I'm sorry. Would you like to be heard at the bond?
I do, I'm sorry, Judge.
Good morning.
He has the violation of probation. Good morning, how are you? He's got the no bond hold with the violation of probation. What I would be asking is that the bonds be kept minimal. He indicated that he doesn't believe that he would be able to afford the bonds that the state's asking for. So that I would ask for the court to just consider reducing the bond as much as possible and setting the bond as low as possible at this point.
Okay, on count 1, aggravated child abuse, count 2, battery, and count 3, throwing a missile into a vehicle, I do find probable cause. On count 1, I'm going to set bond in the amount of $2,500. Count 2, bond is going to be set in the amount of $1,500. And in count 3, bond is set in the amount of $2,500. As you said, he is being held no bond on the violation of probation. He'll need to see the judge. Looks like he may see that judge tomorrow at 8:30 in the morning. Okay? All right.
Thank you, Judge.
Thank you for being here.
And I apologize, Your Honor, did the court order no contact?
Oh, yes, I'm sorry, no contact. No contact means he can't have any contact with,
I'll explain that to him. Judge, can we also get a photo order with regards, he has an injury under his eye?
okay. Be happy to sign a photo order. Do I have to do something on the no con, can I put on, could I have that just go back? I need to. Okay. Okay.
So I'm like balancing.
All right, Mr. Shate, the first one you have is on page 3, Vanessa Maria Daly.
This is a 2013 KBS.
medical reset, Your Honor.
Okay.
Good morning.
Good morning. Okay. Medical reset on that. Next, we have Latonia Denise Thomas.
North Broward.
Are you Latonia Denise Thomas?
Yes.
Okay. Mr. Shate, you have an attorney here for you, Mr. Shate.
Judge, the city of Dania Beach was going to be offering time served on this matter. 3 KPSs, 3 trespasses, all the same thing.
Have you spoke to her?
Judge, it's all taken care of.
Ms. Thomas,
Yes.
you had a chance to speak to Mr. Shate, your attorney?
You need to speak to me, Ms. Thomas. The offer is time served.
All right. God bless you guys. And Merry Christmas. Merry Christmas.
Wait, raise your right, I need you to raise your right hand. You,
Oh, they have lunch?
you swear or affirm to tell me the truth?
Yes.
All right, you're here on 3 separate cases of trespass.
Yes.
You can put your hand down.
Okay.
Can't go back to the locations that are listed in this affidavit, you understand?
Oh, yes.
You're represented by Mr. Shate. Have you had a chance to talk to him?
Yes, he just said time served.
Okay, you understand you have a right to have a trial on these charges?
A trial? What do you mean?
Do you understand? You have the right to have a trial, but you're not going to have a trial if you accept the offer. You should just.
Oh, yes, I accept time served.
Okay, do you understand that means you're entering a plea to 3 separate criminal charges?
What do you mean?
You understand what you're doing here?
Yes, time served mean I get to go home.
Right, but do you understand what you're charged with?
Yes, I can't go back to Family Dollar, right? It's Family Dollar.
It's more than Family Dollar.
Okay, and
You even have the addresses?
And I can tell you as a friend of the court, I know one of the cases, 19-10591 MO10A, involves a Walgreens at 700 West Broward Boulevard in Fort Lauderdale.
Was that the city of Dania?
She was arrested in Dania, the city of Fort Lauderdale, I'm sorry, I misspoke before.
Is the city of Fort Lauderdale?
Yes, with Ms. Kazin.
Okay.
okay, I won't go to Walgreens or Family Dollar.
Where are you gonna go?
I'm going home soon. I'm going home.
Okay.
Second case involves the same Walgreens. And they all involve the same Walgreens.
Okay, you can't go to the Walgreens, you understand that?
Yes.
Okay, if you go there, they're gonna arrest you.
Okay.
You wanna enter a plea of no contest to these charges?
He's already said time served, so I won't go to the Walgreens or the Family Dollar.
I wanna know if you wanna enter a plea of no contest or guilty to these charges.
What does that mean, ma'am?
Mr. Shea?
If I can, I'll give her another call. I'll explain to her.
Okay.
tell her what's
I
going on. I've dealt
just-
with her once before, Judge.
Okay, I
so-
just, there has to be some sense of
Yeah, no,
understanding
I'll-
here.
No contest means that I was in front of the Walgreens.
Okay, I'm gonna let you,
I'll call you in a second, okay?
I'm gonna
Ms.
let you
Thomas?
take a minute to talk to your attorney in a minute, okay? So just have a seat. Tony Wells.
Sorry. Oh.
Tony Wells?
Wells, come on. Angel.
Main jail.
You got an answer?
Mr. Wells,
Yes.
you're here for a warrant, or capias, a misdemeanor warrant. Mr. Shate is standing here. He represents you on this charge for failing to appear. Mr. Shate?
Judge, I'm trying to find the page. 14, I'm sorry. Okay. Yes, Judge, another city of Fort Lauderdale matter. They have offered time served on this.
Mr. Wells, have you had enough time to speak to Mr. Shade about your case?
Yes.
Are you satisfied with the advice you've received?
Yes.
You're charged with a municipal ordinance violation, but it's a second-degree misdemeanor. You want to enter a plea to that charge here this morning?
Yes.
You understand that you don't have to do that? Sir?
You have to hit the button, sir. Tony, hit the button there in the middle.
Yes, ma'am.
You understand that you have the right to have a trial on this case?
Yes, ma'am.
How would you like to plead, guilty or no contest?
No contest.
Okay, I'm gonna adjudicate you guilty. Sentence you to time served. $293 in court costs. 6 months to pay the $293. Michael Laudier.
Judge, I've already been appointed on this matter once prior to this, and then he capious from Judge Diaz's division. It was a time-served offer then and still is now.
Where is he?
He should be in the main jail.
Mr. Lottier? Mr. Lottier.
Judge, he's coming up now.
Okay.
Good morning, Your Honor.
Good morning, Mr. Lottier. You're here this morning on a capious or a warrant for failing to appear on a trespass charge with Judge Diaz. You understand that?
I didn't even know I had a court date.
Mr. Shade is here as your attorney. Have you had a chance to talk to him about your case?
No, I've
I
talked to
didn't
no
speak
one.
to him this morning, Judge.
Okay.
But it is a time-served offer if you'd like to accept that.
Mr. Lottier, you look in the screen, you can see Mr. Shate standing there. He's been appointed to represent you in this case. The offer from the city of Fort Lauderdale is time served if you want to enter a plea to this charge. Is that what you'd like to do?
Yeah, I just had a no contest on it.
Okay.
I mean,
You
I didn't even know I had a court
Do you
date or
understand
one.
that means I'm going to adjudicate you guilty and sentence you to time served?
Correct.
Is that what you want to do?
Yeah, yes,
How would you like to, raise your right hand, please?
right.
Raise your right hand, please. Do you swear or affirm to tell me the truth?
Yes,
You can put your hand down. You understand the charge against you is trespass,
yes.
okay?
Yes, I do.
How would
Go
you,
ahead, man.
how would you like to plead, guilty or no contest?
I'll go with no contest.
I'll adjudicate you guilty, sentence you to time served, $293 in court costs. I'm gonna give you 6 months to pay the
Oh,
200,
Lord.
6 months to pay it. Good luck to you, sir. Hammond? Hammond. Terrence Hammond.
Hello?
No problem, Your Honor.
I spoke with Mr. Hammond, and he would like to accept a time-served offer on this as well.
Mr. Hammond, you're here this morning charged with trespass. It's a municipal ordinance violation. Mr. Shate is here representing you. Have you had a chance to talk to him about your case?
I believe so.
Are you satisfied with the advice you received from Mr. Shate?
Yes, ma'am.
You're charged with trespassing at the Wawa on Broward Boulevard. You understand that?
Yes, ma'am.
Charge is a second-degree misdemeanor. Means it's punishable by a maximum of 60 days. If you want to enter a plea today, I've sentenced you to time served.
Yes,
How would you like to plead?
guilty.
I'm going to adjudicate you guilty of trespass, sentence you to time served at $293 in court costs. I'll give you 6 months to pay the $293. Okay?
Sure.
Good luck to you, sir.
I think that's it, Judge. I'll give the other young lady a call, Miss Thomas,
What's her name? It's Thomas.
Latonia Thomas. I'll give her a call right now.
Okay, we have Madison Lynn George. Okay, Miss George, you're here this morning charged with touch or strike battery, domestic violence. I do find probable cause as to that case, or that charge. What says the state?
Your Honor, the state would be requesting $1,000 bond with no victim contact.
I'll hear from you. I'll hear from you, counsel, with regard to bond.
Judge, at this point, we would just ask we would agree to the $1,000.
Okay. Set bond in the amount of $1,000. I'm gonna order no contact with the victim in this case.
Hey, guys, yo, y'all see somebody at the podium, y'all gotta be quiet.
Is it gonna be on my
Judge,
number?
the main jail is asking for a couple of cases to be called out of turn.
Okay,
Maybe more than a couple.
more than a couple?
More than a couple.
Okay,
I can give them to you
okay, let me just get some,
chronologically.
okay. Go
Page
ahead.
11, bar.
Bar,
Yes, ma'am.
okay.
Page 21, innocent. Page 21, Burgos. Page 22, Swain. Page 23, Duperret.
How do you spell that?
Dubrenat.
Okay,
Page 27, Johnson. Page 27, Harris. And page 28, Rubino. They're all at the main jail.
Rubino,
Yes, ma'am. Oh, thank you.
okay. All right, guys. All right, Mr. Shader, are we recalling Ms. Thomas?
Yes, Judge, I spoke with her. She's just.
Hang on, where was she?
She's in North Broward. She's just a little nervous, Judge, and very hungry, she says.
Ms. Thomas?
Yes,
You understand that there are 3 separate cases against you,
yes,
and there are 3 cases of trespass.
right,
In each of those cases, there was a warrant for your failing to appear in court. That's why you're here, you understand?
yes, he says time served, so,
Okay, so the person who's standing in the, that you can see is Mr. Shade. He's an attorney. Did you talk to him?
yes,
And are you satisfied with the advice you received?
yes, he said time served,
Okay, so I need you to tell me that you understand what you're charged with.
yes,
And I also need you to understand that you have the right to enter a plea today if you want to, of either guilty or no contest, but you also have the right not to do that if you don't want to do that. What would you like to do?
he said that I can say, that I'll take it to trial,
Okay, you can say that. You can also say that you don't want a trial and you'd like to plead guilty or no contest, and I would sentence you to time served.
okay, yes, I want time served,
Okay, would you like to plead no contest?
yes,
Okay, I'll accept your plea of no contest to each of these charges. As to each of them, I'm going to adjudicate you guilty.
cause
Gonna-
guilty,
Time served.
okay, God bless you, time served,
And you're gonna have court costs that must be paid. I'll give you some time to pay that.
okay. So I have time served, meaning I go home today, and then I pay the court costs,
Right.
okay,
And I'm gonna enter an order that you can't go back to that Walgreens.
okay,
You understand?
yes,
That's a court order from me.
okay.
Okay.
Thank you, Judge.
All right, thanks so much. Appreciate it. Okay, on page 11, Calvin Leonard Barr. Mr. Barr is here this morning charged with touch or strike battery and violation of an injunction for protection against domestic violence. I do find probable cause as to those two offenses. What says the state?
Your Honor, as to count one, the state will be requesting a $3,000 bond, and as to count two, a $3,000 bond as well, Your Honor.
Counsel?
Judge, I can tell the court that he's lived here since 1990. He is not currently working, however, he is a veteran. He indicated that he does have family members here, and they can afford some bond, but not a lot. What I would be asking the court to do is set bond with regards to count one at $1,000 and count two, $500.
Well, the reason for the state's request for $3,000 bond, he does currently has, December 15th, he currently has a unfiled case that's presented to the state, violation of injunction, which is the same victim. September, he has a filed case that's currently in Veterans Court, which is a battery violation of pretrial release, same victim. March of this year, a domestic violence that was declined, but it's still the same victim. It was a battery. Currently a pending felony of November 2018, which is an introduced contraband into jail, possession of cocaine, and a battery on the same victim. In addition to this, other priors, Your Honor, which is a 2011 aggravated battery with a deadly weapon out of Miami-Dade, adjudicated guilty. Criminal mischief, adjudicated guilty. The 2011 domestic violence, violation of injunction, adjudicated guilty. Criminal mischief, adjudicated guilty. 2010 Miami-Dade, so it's aggravated stalking. That was dropped. I'm not sure if that was the same victim or not.
Okay, on count one and two, I find probable cause. On count one, I'm gonna set bond in the amount of $5,000. As to count two, I'm gonna set bond in the amount of $5,000. There's absolutely no victim contact as a condition of the bond.
And also ask for surrender of firearms and weapons, Your Honor.
Surrender any weapons. On page 21, Jeffrey Innocent. Jeffrey Innocent?
He's on his way up there. Judge, Mr. Innocent, we'd be asking for a photo order for his injuries.
Okay. Mr. Innocent's here this morning charged with grand theft auto, possession of cocaine, possession of heroin, resisting an officer without violence, failure to stop or remain at an accident involving non-serious injury, aggravated fleeing with injury or damage, and driving while license suspended, second offense. I do find probable cause as to each of those offenses. State?
Your Honor, based on these allegations, the nature of the allegations also, I would consider Mr. Innocent to present a flight risk. On count 5, I'm requesting a $2,500 bond. On count 6, I'm requesting a $10,000 bond. Pretrial release of the GPS monitor, noting, Your Honor, the extent he went to flee from the arresting officer, and I know the court's familiar with the allegations. I'm showing 2 pending resistings without violence, one with the unlawful use of false name ID. 2008, he was convicted of and violated probation on burglary of a dwelling, grand theft, actually 3 counts of grand theft, 3 counts of battery on a law enforcement officer. Upon the violation of probation, he was sentenced to just under 71 months in Florida State Prison.
Counsel, I'll hear from you.
Judge, I can tell the court that he's lived here for 28 years, that he is single. He has 2 children that are 13 and 2. He does have a job. He installs and does maintenance on hurricane shutters. He has a little bit of money. He would be able to afford the bonds that were on the cases originally, but for the count 5 and 6. We were going to ask for the court to set bond on count 5 and 6 at $100 because he is very borderline as to whether he can post that or not. So that's what we would be asking the court to do. I would just ask you to keep that into consideration when setting the bond.
Okay, on count 1, bond is set in the amount of $1,000. Count 2, it's $1,000. Count 3, it's $1,000. Count 4, it's $100. On count 5, it's $2,500. As to count 6, bond is set in the amount of $10,000. Marco Burgos. Mr. Burgos is here on a violation of parole.
Probation, ma'am.
It says parole. But it's a violation of probation alleged in the short arrest form. But the booking says violation of parole. But I show a violation of probation warrant. Is that what you show as well, State?
I don't have the paperwork in front of me. I don't know if confinement status has that. So that should that be a correction?
Is it parole? Okay. Okay. And I do see that there is a confirming paperwork, so I do find probable cause. There's no bond on that. Justin Lamar Swain. That's okay. Okay, Mr. Swain, count 1, criminal mischief, $200 or more, but under 1,000. Count 2 is loitering and prowling. Count 3 is a violation of pretrial release warrant. And count 4 is a capias for a misdemeanor case. I do find probable cause as to those offenses. What says the state?
Your Honor, considering that he has a no bond hold from Judge Malika on one of his pending cases, I'm not asking for any modification.
Okay. Bond in count 1 is set in the amount of $1,000. There's a no bond hold from Judge Malika on the violation of pretrial release, and there's a bond of $100 on the capias. We do need to set it with Judge Malika. So let me see what division that is. Division MT. Page 23, Volvic Dubrenat.
Hey, how you doing, Your Honor?
Hi, good morning.
Good morning.
You're here this morning charged with grand theft auto. I do find probable cause for that offense. Bond is set in the amount of $1,000. What says, either side want to be heard?
Judge, I can tell the court, he indicated to me, he's lived here all of his life, that he has no children. He works as a cook for the Jungle Queen. He does have family members here, but he doesn't have money. I believe this may also be his first offense. So we were gonna ask the court if, in light of that, if the court would consider RORing him. If the court's not inclined to do that, I would ask you to leave the bond in the same amount.
State, does he have any priors?
2017 municipal ordinance, Judge. That's essentially all I see.
Okay. What's your position with regard to pretrial release?
Your Honor, based on the totality of the circumstances, I wouldn't insist upon monetary release. I'd be okay with pretrial, but I know Mr. Farberic is requesting either ROR or $1,000 bonds.
If I can have 1 second to discuss pretrial with him.
Okay.
Judge, you would accept the pretrial release if the court's inclined to do that.
Okay, I'm gonna release him on his own recognizance to pretrial release. Standard release, which would be, how many times a week would he need to call in? Okay, 2 times per week call in.
I'm sorry, Judge, you said call in 2 times a week?
Yes.
And report once a month, is that?
Standard pretrial release, he's gonna be released on his own recognizance. He's gonna call in 2 times per week.
Okay, thank you,
Okay,
Judge.
all right. On page 27, it looks like Kenneth Bernard Johnson.
Judge, you're bringing him from the back, it'll take just 1 second.
Okay. Okay, Mr. Johnson, you're here this morning charged with robbery, no firearm or weapon alleged, and a probation violation where there's a no bond hold on that warrant for the charge of grand theft, violation of probation. I do find probable cause. What says the state with regard to bond on count 1?
Your Honor, based on the totality of the circumstances, I'd be requesting a $5,000 bond and no victim contact.
Okay. You want to be heard?
Judge, in light of the fact that there's a no bond hold, we just ask that you set the bond at this point.
Okay, I'll set bond in the amount of $5,000 on count 1. Also, no victim contact. Being held no bond on the violation of probation. You'll need to see your judge on the violation case. Gregory Eugene Harris. Mr. Harris, you're here charged with possession of alprazolam. I do find probable cause for that offense. Either side want to be heard as to bond?
Judge, I can tell the court that he's lived here all of his life. He does have a job working for a car detailer. He has two children that are 4 and 12 years old. I don't believe that he has any priors. He indicated to me that he's never failed to appear in court before because he has no priors. What I would be asking the court for a couple things, actually. Number one, he was trying to contact family members to get him out of jail so that he can be home with the family for the holidays because he does have two younger children. So I would need an order for him to use his cell phone. The issue is I don't know how quick the jail is going to be able to do that. So in light of that, I would be asking the court to ROR him on this charge so that he can be out, especially in light of the fact that he indicates he has no priors. The second issue is that he is not being given the correct medications here. So we need an order having him seen by medical to make sure that he gets the appropriate medications.
My medications are in my bag.
Okay, State, does he have any priors?
My concern is, if I just have one moment.
Okay.
Okay, Your Honor, my concern is, in 2018, he had a compulsory school attendance violation. He was arrested August of this year on a capias for failing to, the case ended up being dropped, but he was arrested in August of this year on a capias for failing to appear in court, and he posted a $500 bond. My concern ultimately is that he's representing to Mr. Farber that he's never failed to appear in court. That's clearly not true. It was only a few months ago that he was arrested on a capias for failing to appear in court. As far as Broward, that's all I see. I don't know if he has anything elsewhere.
Judge, he's indicated, and apparently it was an issue, I guess, with the his wife, that he was in California at the time. He wasn't aware that he had classes to do. They were separated.
So you can ask him if he'd like $1,000 bond to stay at his, or if he'd like the pretrial release with a monitor with no alcohol or intoxicants.
One more second, Judge. Judge, the concern is this. He wants to know if he's going to get out today because there's an electronic monitor condition. I can't promise him that. It's not like standard pretrial in that. He had money in his property, but I know the court doesn't have a property receipt, and I don't either. He's not sure if it got placed in the file. I don't know if the court has that. But I can't tell him whether he has that or not. That's what the discussion was.
Okay.
So what would you prefer to do? Would you rather get out with the electronic monitor? And again, we can't promise you when you would get out, but as soon as they have a monitor available, they would do that? Or would you rather post your bond?
Your Honor, if I may address a second?
You have an attorney standing right there next to you. That's the best thing to do is talk to the attorney.
Okay,
If I can have just one more second,
Okay.
So Judge, he wishes to accept the pretrial release with the monitor.
Okay. So I'm gonna, ROR him to pretrial release. The GPS monitor. Level,
I'm fine with level 2, Your Honor.
Two?
That allows him to work.
okay.
Is the court also going to be ordering drug testing?
It's gonna be, random testing. And no alcohol or intoxicants. Anything else? Okay. Do you wanna come back? I can't interrupt you to sign these right now, so you wanna just call you when I'm done? Just leave me your number and I'll take them with me and I'll call you. All right, I have one more, then I can call you, Mr. Hancock. If, just one more. Mr. Stephen Vincent Rubino. Mr. Rubino's here charged with trespass of an unoccupied structure. Also, there is a out-of-county hold for failing to appear out of Indian River County. That hold has no bond. As okay.
It's $4,000 bond.
4,000? Okay, so that was already corrected, or I need to correct it on this paperwork? Okay. Actually, on the booking sheet, it shows a $4,000 bond. Oh, okay. So I just need to correct it on this probable cause determination sheet, right? Okay, it looks like, Mr. Rubino, you have a $4,000 bond out of Indian River County. As to the trespass charge here, the bond is $25. I do,
Judge, I'm sorry, I didn't mean to interrupt.
I
Judge,
find probable cause as to the trespass.
I apologize. Judge, he wanted to know if he can work out the trespass charge so that he would be available for Indian River to come and pick him up.
Okay, it looks like it is a trespass charge.
Position physically to make that trip
I can check. See.
Pardon me?
Your Honor, if you'd like, I could check to see what type of structure we're talking about here. I don't think it's specifically referenced in the PC.
It says structure.
I'm running the address.
Okay.
And it looks like it's just the general storefront. I think there's multiple businesses there, so.
If Mr. Rubino wants to enter into a plea to the trespass charge today, I would sentence him to time served plus court costs.
Judge, he wishes to accept that.
Wouldn't raise your right hand, sir? You swear or affirm to tell me the truth?
Yes, ma'am.
You can put your hand down. You're charged with trespass. The way it's charged against you is charged as a second-degree misdemeanor, means it's punishable by a maximum of 60 days in the county jail. You have the right to have a trial. If you'd like to enter a plea today, you can do so. Would you like to enter a plea?
Yes, ma'am.
How would you like to plead, guilty or no contest?
Guilty.
I'll accept your plea. I'm going to adjudicate you guilty of trespass, sentence you to time served, $293 in court costs, and give you 6 months to pay the $293. Your bond on the other case is $4,000.
Yes, ma'am.
And Judge, can we also get a phone order so he can call somebody to help him post that bond?
Mr. Reedy will be happy. You do that for us?
Thank you.
All right, thank you. Okay, we have Franz Joseph. Where's Mr. Joseph?
Good morning, Your Honor.
Good morning, Mr. Joseph. You're here this morning. You're charged with 1 count of driving under the influence, 2 counts of driving under the influence with property damage, and 1 count of resisting an officer without violence, and driving on a suspended driver's license. I do find probable cause as to each of those offenses. Your attorney, Mr. Hancock, is present here this morning. Can you see him? Can you see him?
Can you hear me? Yes, ma'am.
Okay, and you can see Mr. Hancock?
Yes, ma'am.
Okay. What says the state with regard to bond?
Your Honor, I'm just asking that the bonds be left in place.
It'd be left as they are. Mr. Hancock, you want to be
That's fine,
heard?
Judge.
Is that a fine?
Yeah.
Okay.
Can I request something, Your Honor?
Hang on a second. You have an attorney here speaking for you. Your bond is on count 1 is, your bond on count 1 is $500. Your bond on count 2 is $1,000. Your bond on count 3 is $1,000. So a total of $2,500 bond. Anything you say, let me just tell you, you might want to listen to your attorney first. Listen to him.
Mr. Joseph, if you have to say something, just don't talk about the facts or anything of the case.
Right. I just want to make a request.
What is that?
I have a toy drive tomorrow morning. I was wanting to see if I can get an ROR to get out by tonight so I can set it up for the toy drive tomorrow, Your Honor.
And Your Honor, respectfully to Mr. Joseph, I took into consideration the date of his prior, but considering that he posted a $1,500 bond 3 weeks ago on a VOP on a DUI that's going to be heard January 9th by Judge Gottlieb, and this is that warrant may be amended to include this new DUI. I think these bonds are reasonable.
Mr. Joseph, I think you're where you need to be with these bonds right here, so you can talk to your attorney about anything else. Your bond is set in the amount of $2,500. Okay. Okay, anybody else need to be called out of turn, Mr. Reedy, as far as you know?
Not as far as I'm aware, Your Honor.
Okay. All right, so we'll go through the docket then. We have Rose, Marnell, Jean Louise.
Brian, Judge, I am asking also for an order to get her cell phone so she can get a number out.
Okay, we need a cell phone order.
Please, thank you.
Ms. Jean Louise, you're here this morning charged with touch or strike, battery, domestic violence. I do find probable cause on this case. What says the state with regard to bond?
You know, the state was requesting $1,000 bond with no victim contact.
Okay, what's it?
Judge, I can tell the court that she's lived here for 25 years, that she's divorced. She has 4 children. Their range in age is from 25 down to 11. She does have family members that live here in the area. She indicated to me that she hopefully can post 1,000, but she's not 100% sure. She wanted to know if the court would consider something less. I don't believe she has any prior. I'm sorry, I read the wrong thing.
Any prior history?
I'm sure no Florida.
Also, my car is at the house.
Pardon?
I'm sure no Florida priors, Your Honor.
Okay. Okay, I'm gonna reduce bond, we're gonna set bond in the amount of $500. No victim contact.
Judge, she indicated that she has a car over with the victim. Hold on. She has some stuff over there.
She can make arrangements to do that with law enforcement, but she is not to have any contact, direct or indirect, with the victim in this case.
Perfect. Thank you, Judge.
Okay. Carla Joseph. Thank you. Carla Joseph?
Well, they sent her downtown this morning.
Okay.
She's here. She's at Maine.
No, okay, they have
Okay.
her at Maine, Your Honor.
Thank you.
You're welcome.
Okay, we have Miss Joseph. You're here charged with touch or strike battery, domestic violence. I do find probable cause for that offense. State,
State's requesting $1,000 with no victim contact.
okay. You want to be heard as to bond?
Briefly, Judge, she indicated she's lived here all of her life, that she has one child that's aged 5. She works as a nurse. She also has family members that live here. She has no prior record. We would be asking the court to consider an ROR. We understand there would be no victim contact.
You show any priors?
I'm sure no priors, Your Honor, but if you're inclined to RRL, the state's requesting the standard pretrial, Your Honor.
Could she, you rather have standard pretrial or a $500 bond?
Judge, she'll take the $500 bond.
Okay, set bond in the amount of $500, no contact with the victim in this case.
Tori Samuel.
Yes. Yvette Lachey Carter.
No problem, John.
Ms. Carter, you're here this morning charged with aggravated battery with a deadly weapon, domestic violence. I do find probable cause as to that charge. State?
Based on the totality of the circumstances, the allegation that at least one of the children were present, I'm requesting a $3,500 bond, no victim contact. I see no history.
Want to be heard, Mr. Reedy?
Yes, I do, Judge. From what Ms. Carter indicated to me, she is not going to be able to make that kind of a bond. I am going to try and get a hold of her mother after court to see if any money can be raised. She has lived here all of her life. She's been living for the last 5 months with her mother, so she will not be having any contact with the alleged victim in the case. As the state mentioned, quite correctly so, this is the first time that she has ever been arrested. She does have some physical health issues that concern me as to whether or not she's going to be receiving appropriate treatment in the jail. So I'm going to ask the court to consider pretrial release for Ms. Carter.
Yeah, I'm going to set bond in the amount of $1,500. Also pretrial release. Standard pretrial release. No victim contact.
And Judge would be requesting a phone order also.
And I'll sign a phone order.
A photo, I'm sorry, photo.
Photo order. Okay. Bond is at $1,500 with pretrial release. No victim contact. Understand?
Yes,
Okay.
Good luck, Ms. Carter.
thank you.
Diana Marie Culbertson.
Medical research, Your Honor.
Okay. Dernike Johnson.
All right, Your Honor.
Good morning, Your Honor.
Good morning. Ms. Johnson, you're here on an immigration hold. If you find probable cause, the immigration hold has been, the paperwork has been filed, and that is a no bond hold on you, okay? Noah Daphne Shamblin.
Judge, you decline the public defender.
You, Ms. Shamblin?
Yes.
Okay, you're here this morning charged with driving under the influence of alcohol. driving under the influence of alcohol with property damage, failure to stop or remain at an accident scene, and failure to use due care. I do find probable cause as to those charges. Bond, does the state want to be heard as to bond? I need to set bond on count 3. Pardon? Yes. Bond on count 1 is $500, bond on count 2 is $1,000, and bond on count 3 is ROR. Total bond is $1,500, okay?
It's my understanding, Your Honor, that her family is going to be bonding her out.
Okay. Did you hear that?
Yes.
Okay. Jacqueline Denise Bass.
No problem.
Yes, Your Honor.
Ms. Bass, you're here this morning charged with possession of drug paraphernalia, disorderly conduct, and tampering with or fabricating physical evidence. You understand that?
Yes, yes, Your Honor.
Okay, I do find probable cause as to each of those offenses. What says the state with regard to bond with regard to Ms. Bass? State want to be heard?
Yes, just one moment, Your Honor.
Okay.
Yeah, I'm not asking for anything. Your Honor, I wasn't gonna be asking for any type of modification.
Okay. Defense want to be heard?
Yes, Judge, I'm going to be asking for pretrial release. It's my understanding that Ms. Bass has been living here her entire life. She's lived at the same location her entire life. She lives with her sister. She indicated to me this is not the first time that she's had contact with the criminal justice system, but the last time that she had contact with the criminal justice system, she indicates to me, was some time ago. And it appears that the evidence in the case was a crack pipe that she tried to step on when she was detained for the disorderly conduct.
Ms. Bass, do you have a place to live?
Yeah. Yes. My sister don't let me stay with them.
Okay.
Your Honor?
Yes.
I wouldn't have an objection to pretrial with the conditions, one, that it be pending verification, and that there be random testing.
Okay. So I will release her on her own recognizance to pretrial release. Standard. With the condition that her address be verified first.
And Your Honor, if you're gonna do that, then you would keep the bond on count 3 at 1,000. Once pretrial verifies the address, it'll automatically turn into an ROR.
So what do I put on this? Leave it here?
Just release the pretrial pending verification.
Okay. Yes, random testing. Ms. Bass?
Yes, Your Honor.
Okay, they're gonna verify that you have a place to live, and if you do, then you're gonna be released to pretrial release, okay?
Okay.
Okay.
Good luck, Ms. Bass.
Okay.
Sinead Jean Crosswaite? Ms. Crossway is charged with possession of a controlled substance without a prescription. I do find probable cause as to that offense. What says the state with regard to this bond?
Your Honor, I'm not asking for any bond increase.
Okay. Defense, want to be heard?
Judge, I can tell the court she's lived here all of her life, that she is not working, she is single. She has no money to bond out, and she doesn't believe anybody's gonna be able to bond her out. So she's asked me to ask the court if the court would consider RORing her.
What do you show for priors?
While I'm looking that up, Mr. Faber, I don't know if she provided you any information where she resides, because I'm showing on the PC affidavit a Davie address and a Pembroke Pines address on the booking. Showing no history, Judge.
The allegations in the probable cause affidavit are concerning with regard to the fact that there were children in the van.
And that's what, Your Honor.
Mr. Linder, I'm sorry.
No,
I
no,
can tell you
go
that
ahead.
she indicated she lives with her mom and Davy.
Your Honor, what I was going to be requesting is, if the court is inclined to set non-monetary release, I was going to be asking that there be random pretrial supervision with random drug testing.
Judge, what we would add, if she can be ROR to pretrial release, she would accept that. I think that's what the state said, I'm not sure.
Okay. I'm going to release her on her own recognizance to pretrial release. Standard. Random testing. No alcohol and no intoxicants as a condition of the pretrial release.
And Your Honor, the only other thing I would just note.
No
Mr.
contact
Verbeek-
with the other
Oh, no,
person?
No, I was going to ask that. Mr. Verberick, she needs to be aware that I don't know if the clerk's going to be sending notice to the Pembroke Pines address or the Davie address. So she's on notice, it's her responsibility to either check in with the clerk, her attorney, or
I know
pretrial
someone who-
about
Yeah,
future
I'll
court dates.
let her know, and she said she knows somebody down there, so she'll do it.
Okay.
Thank you.
No. No, I don't know. Well, let me ask. Do you all know what time they're doing the juvenile hearings tomorrow?
Guessing, I mean, if I had to guess, I would say the same time today since.
Right, we don't know, but if they want to check with the state attorney's office or the public defender's office. Don't know for sure. Today it was 9, it was supposed to be at 11. It was scheduled, they thought it was scheduled for 11, so. Okay. Okay, we have Jacqueline Ann Bendel.
North Broward.
Ms. Bendel, you're here this morning charged with resisting an officer without violence. And you're here on a violation of pretrial release on a felony case. And a capias or warrant on a misdemeanor case as well. As to the resisting an officer without violence, I do find probable cause being held no bond on the violation of pretrial release warrant. Bond is set in the amount of $500 on the misdemeanor capias, and bond is set in the amount of $100 on the resisting an officer without violence. You do have a status hearing scheduled for tomorrow for the misdemeanor case. I think that's FH.
Here?
No, on the felony, there's a hearing scheduled for tomorrow at 8:30 with Judge Bailey.
Okay,
Okay?
thank you, thank you.
You tell me if I'm going too fast. Am I going too fast? Okay. Shavonna Rochelle Wright.
Main jail, she refused the PD.
Main jail?
Yes, she refused the public defender.
Okay, Miss Wright, you're here this morning. You're charged with possession of a forged driver's license or ID, possession of a forged driver's license or ID, grand theft of $1,000 or more but less than 20,000, obtain property by false personation, illegal use of a credit card to obtain goods over $300, fraudulent attempt to use ID of another person without consent, and a probation violation. The probation violation is a no bond hold. Does the state want to be heard as to bond?
Your Honor, considering she has a no bond VOP hold out of date, nothing from the state.
Okay. And so your bond is set, 1, 2, 3, 4, 5, 6 counts, $1,000 each, a total of $6,000, and you're being held no bond. I do find probable cause as to each of those offenses. Nicole Yolanda Johnson.
No problem.
Miss Johnson? Where's Miss Johnson?
Johnson's here.
Okay, sorry. Miss Johnson,
Yes.
you're here this morning charged with possession of cocaine. I do find probable cause as to that offense. And what says the state? You want to be heard or not?
No, Judge.
Okay, defense?
Judge, I'm going to ask the court to consider releasing Ms. Johnson or leaving the bond where it is. She's been a resident of Florida her entire life. She's been staying in the same location for several months with her aunt, which is where she would return if she was released. She did indicate to me that she has 2 prior contacts with the criminal justice system and that they were sometime in the past.
What do you show for priors?
She's had contact a lot, much more recent, Your Honor. I'm asking pretrial to look into it. She was arrested on an aggravated battery in May of this year. She was placed on pretrial. It was dropped. I'm just asking pretrial to check in their notes to see if there were any issues, whether she was complying with pretrial.
I'm going to leave bond in the amount of $1,000.
Thank you, Judge. Oh, and I'm going to be asking the court to sign a phone order for Ms. Johnson as well.
Okay. We have Michelle Christina Winkler.
Hi, Honor.
Good morning.
Morning.
This case
Your Honor,
looks
is
like
up
it was
for
a
perfection.
reset.
It was up for perfection, Your Honor.
Okay.
I have no new information for the court, so Ms. Winkler's entitled to an ROR at this time.
Okay. Okay, so yesterday, Judge Uson found no probable
I
cause.
think it was Saturday, Judge.
Saturday,
You have 48 hours.
it gave 48 hours to perfect, set it for the 23rd, which is today. So, having been a finding of no probable cause, you're going to be released on your own recognizance on this charge. That doesn't mean the state might not file the charge, so you need to follow up with it, but for purposes of today, you'll be released.
Okay, thank you. Merry Christmas.
Okay, good luck.
Thank you.
Okay, I have Elena Margarita Sosa.
Hold on, Your Honor.
I have this as just count 3. 2 of the other counts are crossed out. Okay, so this is for an out-of-state hold from North Dakota, an add charge that has been added. It's an out-of-state hold with, looks like no bond. Is that right? So they're holding you, they have a no bond hold from North Dakota. I do find probable cause as to that, and that's an additional charge, okay? Rosemario DeFore.
Good morning, Your Honor.
Where's that?
Main jail.
jail. Morning, Rosmario DeFore, here this morning for touch or strike battery domestic violence. I do find probable cause. State, what's your recommendation with regard to bond?
State's requesting, due to the fact that this was done in the presence of their child, the state is requesting a $2,000 bond, Your Honor.
Defense, you want to be heard?
Yes, Judge, I can tell the court that he's lived here for 30 years, that he is currently not working, and he does have family members in the area. I don't believe he has any prior records, and what I would be asking, he's not sure if he can post a bond. I would ask the court if the court would consider consider ROR again.
We're going to set bond in the amount of $2,000. No victim contact. Devon Brandon Hilton. Mr. Hilton is here charged with touch or strike battery domestic violence. I do find probable cause as to that offense. What says the state with regard to bond in this case?
I'm sorry. State will be requesting a $1,000 bond, no victim contact.
You want to be heard as to the bond?
I do, Judge. He indicated to me he's lived here for 19 years, basically all of his life. He said that he has no money in the bank. He currently works at a restaurant. He's also enrolled in Broward College, and I believe he goes back in January. He does have family members here, but he doesn't believe that they're going to be able to post that bond for him. We would be asking the court to consider an ROR.
Has there been any contact from the victim in this case?
Oh, Your Honor.
Judge, I did speak with his bondsman this morning. The bondsman's trying to work with his father to post bond, but I don't know exactly how much they're going to be able to come up with.
Okay, I'm going to set bond in the amount of $1,000. No contact whatsoever with the victim in this case. Bandath McCoon. Mr. McCoon, you're here charged with touch or strike battery domestic violence. I do find probable cause as to that offense. State?
State will be asking for a $1,000 bond with no victim contact.
Judge, he says that he can post that.
Okay, we're going to set bond in the amount of $1,000. No contact whatsoever with the victim in this case. Anthony Collado.
Judge, he's at the main jail. He declined the PD. I think he's trying to hire private counsel.
Okay.
Good morning, Your Honor.
Good morning, Mr. Collado. You're here this morning charged with touch or striking battery domestic violence. I do find probable cause as to that offense. What says the state with regard to bond?
The state will be requesting $1,000 bond with no victim contact.
Mr. Collado, I'm going to set bond in the amount of $1,000. You're not to have any contact whatsoever, direct or indirect. You understand?
I do. Thank you.
Okay.
Your Honor, Paul Ryan is asking a case to be called out of turn
Okay.
on page 25, toward the end of the court's docket, Pierre Tarnowski.
Sorry, the last name?
It's
First name?
Pierre.
Oh. Okay.
And Your Honor, if I could be heard.
You say that is, North Broward? Paul Ryan.
Your Honor,
Yes.
this matter was actually addressed on Friday.
Okay.
Mr. Dudernowski is represented by Bob Nichols.
Okay.
Mr. Nichols was here. Both of us appeared before Judge Powell with a stipulated agreement. These are ad charges. Some of the original counts were no infoed. Assistant State Attorney Justin Griffiths is assigned the case. What we agreed to, and if you'd like to see, just for the court's edification, I don't know if you have it there, Judge Powell signed an order on Friday. Essentially, that the parties stipulated that there's probable cause for first appearance purposes, setting the bond on these 8 counts at $25,000 each, which would put the bond back at what it was originally set at. So it's actually, if you look in the jail system, he's being held $25,000 per count.
On these counts.
Per the order, yes, that was signed by Judge Powell. Could you show the order, please, just so the court can see it?
Okay.
Technically speaking, we really didn't need a findings because of the order, but just to be safe.
Okay, just so the record's clear, I'm looking at an order that was prepared, I guess, with the agreement of both the state and your attorney on the 20th of December, and it indicates that based on a stipulation of the parties, the court finds probable cause and sets bond at $25,000 per count. All previous release conditions remain the same, and this order was issued for the purposes of the first appearance and is made without prejudice. So it specifically says 5, 6, 7, 8, 9, 10, 11, and 12. So there was already previously an order entered. I guess on this I should just,
Your Honor, just to avoid any further complication, if the court could fill in the findings just to reflect be consistent with the previous order from Judge Powell.
so I should reflect the $25,000 bonds, yes. As to each of the counts.
Yes.
Okay, Mr. Dudernowski, the bond amounts are consistent with the order that was previously entered by Judge Powell with the agreement of your attorney, okay? Just so you understand. Okay? You can be in touch with Mr. Nichols. Where's this order going to? Back to?
Yeah.
Kevin Davis.
Count 3, Your Honor, as to violation of possession of firearm.
Thank you.
Okay. Count 1 is aggravated assault with a deadly weapon without intent to kill. Count 2 is aggravated assault with a deadly weapon without intent to kill. Count 3 is violation of an injunction for domestic violence with possession of a firearm or ammunition. I do find probable cause as to each of those offenses. What says the state with regard to bond?
Well, Your Honor, on counts 1 and 2, I'm gonna be requesting a $7,500 each. Count 3, $10,000, I'm also gonna be requesting, pretrial release of the GPS monitor. Mr. Davis was ordered by Judge Moon not to have any contact, and I would advise the court, while the charge on count 3 deals with not being in possession of firearm or weapon while in violation of an injunction, I reviewed the injunction. He is also ordered to stay away from, not come within 500 feet of 2941 Northwest 21st Street in Fort Lauderdale. That is the petitioner whose name is Larry Kane's residence. And I would just note that was the place of arrest in this matter. So there are other grounds for violating the injunction.
Your Honor, he's also on pretrial in case number 19003988 CF10A, and pretrial is asking that you revoke pretrial. The charge for that case is grand theft in the 3rd degree.
Okay. I got it. Okay, I do find probable cause as to the 3 charges that are in front of me. I'll hear from you with regard to bond, if you'd like to.
Judge, I did talk to him. He's lived here all of his life. He's single. He has 5 children that range from 23 to a child that's on the way. He indicated that he has no money. He does work doing landscaping work. He said that he does have family members here and they can help, but not a lot. What we were going to ask the court for is $1,000 bond with regards to each count.
Okay, as to count 1, aggravated assault with a deadly weapon, I'm going to set bond in the amount of $7,500. Count 2, $7,500. Count 3, bond is set in the amount of $10,000. As to grand theft, where he is on pretrial, is he on pretrial in lieu of a cash bond or with a cash bond? In lieu of. So I'm going to revoke his pretrial status with regard to that and set bond in the amount of $1,000.
Judge, he's indicated that he can't afford that amount. I don't know if the court would reconsider the amount.
I'm not going to reconsider the amount now. He can see the judge who's the case is going to be in front of for a bond. As a condition of any of those bonds, he's not to have any contact. Keon Deondrick Wright. Mr. Wright is charged with touch strike battery and a violation of probation. In the case is with Judge Yusan with the violation of probation. That case is scheduled for a hearing tomorrow at 8:30. I'm sorry, the 24th, that's tomorrow. He's being held no bond on that case. I do find probable cause as to the touch strike battery domestic violence. What says the state with regard to bond?
Your Honor, requesting a $2,000 bond, no victim contact.
Do you want to be heard as to that? The state's requesting $2,000.
Judge, we would just ask, in light of the fact that he has a no bond hold, if the court would just set a $1,000 bond.
I'm going to set bond in the amount of $2,500 on count 1, and there's going to be no victim contact. Jacoby Wesley Porter. This reporter is here charged with aggravated battery with a deadly weapon, domestic violence. I do find probable cause as to that offense. What says the state?
Your Honor, based on the, I see no history. That being said, based on the level of violence that Mr. Porter allegedly used a firearm to pistol whip the victim, I'd be requesting a $20,000 bond, no victim contact. Obviously, no possession of any firearms, weapons, or ammunition.
I'll hear
Judge,
from,
I can tell you that he's lived here for 25 years. He's single. He has two children that are age 7 and 3. He indicated that he does have family members here. They can afford some bond, a few hundred, but not a lot. He gave me the amount of around $200, so we would be asking the court to set bond at $2,000.
I'm going to set bond in the amount of $5,000. It's not to have any victim contact whatsoever. No weapons or firearms of any kind.
Judge, also I need, if the court would grant it, a order for him to get to his phone to call somebody to help him bond.
Okay, we'll do a phone order. James Harrison.
Yes. No problem.
Mr. Harrison, you're here charged with driving under the influence. Did I check that on that? Okay. Driving under the influence of alcohol, and driving under the influence of an alcohol with a breath alcohol reading of 0.15 or above. I do find probable cause as to that, those offenses. State, do you want to be heard as to bond?
No, Judge.
Okay.
Judge, I'm going to ask the court to consider pretrial release for Mr. Harrison. It's my understanding he's never been arrested before. He's been a resident of South Florida since 1986. He lives with his girlfriend. And he's retired, actually, retired from electric wholesale. He worked in the same job for 40 years, and now he is a Lyft driver.
Well, that's concerning, because he was supposedly just coming off a shift when this allegation occurred. Do you have a driving record?
I don't, Your Honor. I'm being
Driving record
advised.
is on James Edward Harrison.
Your Honor, while they're looking, I'm being advised there's no history, so I don't have an objection to pretrial. I would, however, ask that there be random testing, no alcohol or intoxicants. This is also based on the breath alcohol readings.
Okay, on each of those, I'm going to release him on his own recognizance to pretrial release. No alcohol.
Step back from
No intoxicants. You're subject to random testing while you're out on this release status. And I do find probable cause.
All right.
Patrocinio Martinez Garcia. Bonded? Okay, I do find probable cause. Amit Harry Ramajatan.
He bonded also, Your Honor.
Okay. I do find probable cause for resisting an officer without violence and trespassing. Larry Lamar Quince.
Yes, ma'am. How you doing, y'all?
Mr. Quince is here this morning charged with possession of cannabis, possession of drug paraphernalia, resisting an officer without violence, and a capias or warrant from Division MQ, which is Judge Gottlieb.
Judge, I had a chance to speak to him this morning. I don't know if the court's in a position, but he'd like to try to work this out today.
Well, he's got a pending case with Judge Gottlieb on something else. So he needs to see Judge Gottlieb. This case would go there as well, unless the state wants to make an offer.
I'm just checking to see what the,
I don't see, I think this is gonna be a city case, maybe?
no, these are all state charges.
Okay,
Judge.
state charges. I don't see a Valtox of any kind there.
One moment, Judge. That is accurate, Judge. I can tell you the documented offer from the assigned prosecutor on count 4, the capias, would be a withholding court cost. I would relay that offer to Mr. Quince if it's acceptable to the court.
Okay.
And based on what Your Honor just stated, obviously he's entitled to an ROR on count 1. I would not be asking for time to perfect.
Okay. So the capias that he failed to appear with Judge Gottlieb is operating without a valid driver's license. If he wants to enter a plea to that today, I would withhold adjudication of guilt, impose court costs in the amount of $293 and give him time to pay that. I'm finding no probable cause as it is to the possession of cannabis charge, which means he would be entitled to an ROR if he'd like to. I mean, I am setting an ROR on that case, and I find no probable cause as to count 1. As to counts 2 and 3, I do find probable cause. Would he like to resolve?
He does, yes, Judge.
Okay, would you raise your right hand, sir? You swear or affirm to tell me the truth?
Yes, ma'am.
You're charged with operating without a valid driver's license. The way it's charged as a second-degree misdemeanor, punishable by a maximum of 60 days in the county jail. You understand that? You're represented.
Yes, ma'am.
You're represented here this morning by the Public Defender's Office. Have you had enough time to speak to them about your case?
Yes, ma'am.
Are you satisfied with the advice you've received?
Yes, ma'am.
How would you like to plead, guilty or no contest?
No contest.
I'll accept your plea of no contest. I'm going to withhold adjudication of guilt, impose $293 in court costs, and give you 6 months to pay the $293. Now, you're still going to need to follow up with these other charges. You need to appear in court on those. You understand? Even though I'm releasing you on your own recognizance, you need to appear in court. You understand?
Yes, ma'am.
Okay. Good luck to you, sir.
Thank you. Have a home? Yep.
Samuel Ojeda. Mr. Ojeda, you're here charged with petty theft and committing a theft-resistant recovery of property. I do find probable cause as to those offenses. Bond is set in the amount of $100.
Judge, he also wanted to know if the court could extend an offer for him to plea out today.
State want to make a plea offer on this case?
Yes, Your Honor. Mr. Ojeda has priors, but I see no prior thefts. So the offer from the state would be a withhold, court cost judicial notice of time served, no return to this particular Walmart on Creek Drive in Coral Springs.
Mr. Ojeda, you want to raise your right hand, sir? You swear or affirm to tell me the truth?
Yes, ma'am.
You state your full name for me, please?
Samuel Ojeda.
You can put your hand down. You're charged with petty theft and committing a theft-resistant recovery. That's charged as, each of those charges first-degree misdemeanors. Means that they're punishable by a maximum of 1 year in the county jail. You understand that?
Yes, Your Honor.
You're represented by the Public Defender's Office here this morning. Are you satisfied with the advice you've received?
Yes, ma'am.
You understand if you enter a plea today to theft, the state keeps track of theft charges. If you find yourself back before me or any other judge anywhere in the state charged with a theft-related offense and you have 2 prior convictions for theft, the state could charge it as a felony even if it's a misdemeanor amount.
Yes, Your Honor.
Knowing that, you still want to enter this plea?
Yes, Your Honor.
You under the influence of any alcohol or drugs here this morning?
No, ma'am.
Have you ever been treated for a mental illness?
No, ma'am.
How would you like to plead, guilty or no contest?
No contest.
I'll accept your plea of no contest, sir. As to count 1 and count 2, I'm going to withhold adjudication of guilt. As to count 1, I'm going to impose $293 in court costs. I'm going to give you 6 months to pay the $293. I'm going to waive any additional cost as it is to count 2.
Okay.
Thank you, Judge.
Yep, get up.
William Roboletto.
Hey, Joe.
Oh, main jail?
Oh, is he?
Okay. Mr. Roboletto.
Good morning.
Morning. You're here this morning charged with possession of cannabis. You're also have here on a warrant or capias for failing to appear on a charge of resisting an officer without violence in front of Judge Malika.
Judge, Mr. Rebedolo indicated to me he'd like to resolve both these matters today, if possible.
What's the offer from the state?
Count 1 would be withhold and court costs, credit, judicial notice, time served. 2 would be an adjudication, time served, court costs.
Do you understand the offer, sir?
You'd be
Yes, sir.
you'd be adjudicated guilty or found guilty, convicted of this offense of resisting an officer without violence if you enter a plea here today. You understand that?
Yes, ma'am.
If you'd like to, you don't have to do that today. You have an appointment or a court date to see Judge Malika tomorrow on your case. What would you like to do?
I would like to resolve the case.
Okay, raise your right hand, sir. You swear or affirm to tell me the truth?
Yes.
You can put your hand down. Would you state your full legal name?
William Reboledo Jr.
Mr. Roboletto Jr., you're here this morning. You have 2 separate cases. One is a possession of cannabis charge, and one is a resisting an officer without violence. The possession of cannabis is a first-degree misdemeanor. The resisting an officer is a first-degree misdemeanor. They're each punishable by a maximum of 1 year in the county jail. You understand that?
Yes.
If you enter a plea here today to these charges, the state is recommending that I adjudicate you guilty, convict you of resisting an officer without violence. Do you understand that?
Yes, Your Honor.
You're currently today represented by the Public Defender's Office. Have you had enough time to talk to them about your case?
We just met.
Right.
Yes.
Don't just say yes, who's ever in the background.
Do you need any more time to talk to me, William?
No, you.
Okay, I think we covered everything when we spoke earlier.
We covered up already about the case. I was in bond, and then they told me the charges were to drop, and then they pop up again.
Okay, so the question today is, do you understand that you have the right to have a trial if you wanted to? You don't have to enter a plea.
Yeah.
Is that what you want to do? You want to enter a plea?
Yes.
Okay. Before I can accept a plea, I have to ask you a couple of questions.
Okay.
Are you under the influence of any alcohol or drugs here today?
No.
Have you ever been treated for a mental illness?
Yes.
Are you currently taking any medication?
Yes, Your Honor.
Okay, how do you feel today?
Feeling good.
All right, you also must be advised by me if you're not a United States citizen, entering into this plea and being adjudicated could subject you to deportation and/or a change in your current immigration status. You understand that?
Yes, Your Honor.
Knowing all that, you still want to go forward and enter this plea?
Yes, Your Honor.
How would you like to plead to possession of cannabis and resisting an officer without violence?
No contest.
I'll accept your plea of no contest. As to count one, the possession of cannabis, I'm going to withhold adjudication of guilt, impose $308 in court costs, give him 1 year to pay. As to count, case number 19005-397-MM10A, I'm going to adjudicate you guilty, impose $293 in court costs, and give you 1 year to pay. Good luck to you, sir.
Okay, Your Honor. Thank you.
Good luck, William.
Thank you.
Terrence Maurice Morris. Mr. Morris, good morning, Mr. Morris. You're here this morning on a capias or warrant for failing to appear on a, looks like a petty theft charge. Looks like it's a satellite courthouse case, and was a warrant issued in the amount of $250.
Judge, he wanted to know if the court would consider working this out today.
Your Honor, I don't have an offer. There's a couple reasons why. One, he's got a pending felony. Two, Mr. Morris is a registered sexual predator. Obviously, as the court's aware, any plea could potentially result in involuntary civil commitment.
Okay.
And I just don't know that that's appropriate for the state to make an offer of first appearance.
I find probable cause as to the capias, that there is a capias in existence. Its bond is in the amount of $250.
With the court, he did ask me to ask the court for an ROR. Would the court
Is he,
consider that? Or
is he
reduce
on
the
bond on a felony case?
Yes, ma'am.
No, I'm gonna leave the bond at $250.
Thank you, Judge.
Dixon Boniface Eugene.
Bonded.
Bonded, okay, I do find probable cause. Robert Cassidy. Mr. Cassidy's here on a warrant or capias for a charge from 2017. The charge was petty theft. Do you find probable cause as to regard to the warrant? State have an offer on this case?
The documented offer from the assigned ASA is withhold court costs.
If you'd like to resolve the case today, the offer or the recommendation is withhold adjudication and court costs.
If I can have half a second, Judge.
Okay.
Judge, he wishes to accept it.
Okay, raise your right hand, sir. You swear or affirm to tell me the truth?
Yes, Your Honor.
You can put your hand down. Would you state your full legal name?
Robert Jude Cassidy, Jr.
Mr. Cassidy, you're here this morning. You're charged with a charge from 2017 where you're charged with petty theft. That's a charge, looks like it's charged as a first-degree misdemeanor. Is that right? State?
I'm sorry, Your Honor?
Charges of first-degree misdemeanor? Or is
I
it?
will confirm that. This case is a second degree.
Okay, charges of second-degree misdemeanor, punishable by a maximum of 60 days in the county jail. You understand that?
Yes, Your Honor.
You also need to be advised that if you enter a plea today to petty theft, then the state keeps track of those charges. If you find yourself before another judge anywhere in the state of Florida charged with theft, and you have 2 prior convictions, the state could file a felony charge against you, even if the amount is a misdemeanor amount. You understand?
Yes, ma'am.
You under the influence of any alcohol or drugs here today?
No, I am not.
Have you ever been treated for a mental illness?
No, I'm not. No, I have not.
You also must be advised if you're not a United States citizen, entering into this plea could subject you to deportation and/or a change in your current immigration status. You understand?
Yes, Your Honor.
You satisfied with the advice you've received from the Public Defender's Office?
Absolutely.
How would you like to plead, guilty or no contest?
No contest.
I'll accept your plea of no contest. I'm going to withhold adjudication of guilt, impose $293 in court costs, and give you 6 months to pay the $293.
Thank you, Your Honor.
Alexander Bertram Norris.
Yes.
Mr. Norris, you're here charged with trespass, failing to leave property upon order by the owner. I do find probable cause as to that offense. Bond is set in the amount of $25.
Mr. Norris would like to resolve this if possible, Judge.
It's an offer from the state.
Why so fast? I want to press charges back to them for lying to you.
You want to resolve this case, Mr. Norris, because that's the only reason that we're here today.
I would like to ask a question to the judge. Are
Okay.
you the judge or is she?
I am the judge, and you're being represented by him as an attorney, so,
No, I have a private attorney.
Okay.
I don't need him. He's fired.
okay. Then I'm gonna tell you that I do find probable cause, and bond is set in the amount of $25, okay?
Okay, and may I request anything?
Sure, you can request.
I don't have my wallet on me or my property. It's in property right now.
Right.
And I would also like to request that we come back because I have a private attorney. He can speak on my behalf, and I can come back. It's up to you.
Okay,
But I don't-
so your bond is $25 if you have it in your property. They'll help you try to get that and bond out if you want to. If you have a private attorney, contact your private attorney so they can help you, okay?
Can I just be released on my own recognizance without a?
No, bond is $25.
Would I be going home right now?
When you post the $25, you'll be released.
Well, they haven't even let me make a. You might want to look at what's on that paper.
Okay. Arthur Shaw. Oh, okay.
It's a medical loan.
Use a medical loan, Judge.
Medical loan, okay.
Email.
Jermaine Nathaniel Fudge.
Medical loan.
Your Honor?
Yes,
Actually, on Mr. Fudge,
yes.
just want to see. Yeah, I mean, normally in this type of situation, I wouldn't have an objection to an ROR. But based on these allegations, I think he should appear before a judge to be instructed. to
Actually,
stay
yeah,
away.
there's a,
It's not your run-of-the-mill.
right, so there was originally some notes from a previous judge, so I just leave it there on a medical loan, let him see whoever. I think Judge Benson's here tomorrow, maybe. Okay. Alexis Simon,
It's a medical reset.
okay. Michael James Hummel.
Angel.
Excuse me. Mr. Hummel charged with possession of methamphetamine, drug paraphernalia possession, temporary tag expired, probation violation, no bond, and an out-of-county hold. Two separate out-of-county holds, it looks like. I do, as to the charges here before me, find probable cause. The out-of-county hold is from Hillsborough and Polk County. Do I need to address anything as far as the bonds?
Your Honor, in light of the no bond and other bonds on the out of county, I'm not I'm not seeking any money.
Okay, I'm gonna leave bond then at the amount of $1,000. The others are no bond and $15,000. Wayne Conrad. Pardon?
It's on his way.
Okay. Mr. Conrad, you're here charged with driving on a suspended driver's license as a habitual offender. I do find probable cause of being told your bond has been posted.
What's she saying?
Your bond's posted. Oh. Thank you, Judge.
Andrew James Senra. Mr. Senra, you're here this morning charged with petty theft, a third or subsequent offense, possession of drug paraphernalia, and resisting an officer without violence. I do find probable cause as to...
Judge, I did not see any reference to prior convictions in the probable cause act.
Wait.
He's also currently on pretrial for a felony petty theft in case number 1901-1991 CF10A. Pretrial is asking that you revoke his pretrial in that case.
And Your Honor, if I could just have one moment just for technicalities. I can tell you, as pretrial mentioned, he does have a pending felony theft where it's alleged in the sworn information that he has the qualifying offenses. But I will also show Your Honor, and I'll show Mr. Reedy first, obviously. Come to that in a second.
Is that in lieu of a cash bond?
Yes, ma'am.
Okay.
Judge Duffy on a 2019 case on this defendant for the offense of felony theft. Clearly, he was convicted of a felony theft this year. Then a circuit court judge, Judge Duffy, in this situation found that he does have the requisite qualifying priors.
Mr. Reedy, you had a chance to see this?
I had, Judge.
Okay.
Just had to be sure.
Yes. So it does appear that are basically two sets of documents that would convince the court that there are priors. One is that there is a judgment that was entered by Judge Duffy. Looks like that happened in February of 2019. And there's also an order indicating he's on pretrial release on a felony petty theft in case number 190119991CF10A. So as to this petty theft, what says the state with regard to bond?
Frankly, Your Honor, it really depends on what action the court chooses to take on the revocation.
In this case, before me, thank you. Do you want to be heard on, as to bond?
Maybe Mr.
Okay,
Judge, I can tell the court he's lived here all of his life, that he has two children, aged 13 and 10. He works part-time, he works at a restaurant, but it is very part-time. He only works a few hours a week. So he doesn't have a lot of money to afford bond. He indicated that he would be asking for an ROR with regards to the new charges and that. I would just ask the court to take that into consideration when setting bond.
okay, on the new case, the court's gonna set bond in the amount of $1,500. And on, case number 190119991 CF10A, I'm gonna revoke his pretrial status, set bond in the amount of $1,500. I do find probable cause as to the new offense.
Your Honor, North Broward is asking for a case to be called.
Okay,
It's Mr. Kevin Horton. And he is on page
28.
28. These are the one of the last cases on your docket.
okay, Mr. Horton, you're here this morning charged with grand theft, also dealing in stolen property, and resisting an officer without violence. Either side want to be heard as to probable cause? I do find probable cause unless there's,
No, Judge, no
okay,
probable cause.
okay. I do find probable cause as to each of those offenses. Let me hear from you as to bond, if you'd like to be heard.
Your Honor, I'm asking that the court keep the convenience bonds in place. As far as Broward, Mr. Horton in 2008 was sentenced to just over 36 and a half months state prison as a habitual offender for battery on a law enforcement officer. There was also a count of unlawful use of false name ID. Then going into the 90s, late 90s, grand theft, drug priors, a grand theft in the mid-90s, and Berg structure, grand theft mid-90s.
Judge would be asking you to sign an order allowing Mr. Horton to participate in the SAP program in the jail.
Okay, I'd be happy to do that.
Yeah, or we can give me a year and a day now and take care of all this.
I told you, Mr. Horton, we can't resolve any felony charges at magistrate court.
Okay, so I do find probable cause. Your bond is set in the amount of $3,000.
Thank you, ma'am.
Robert McCowan. Mr. McCowan, you're here this morning charged with petty theft, third or subsequent offense. I do find probable cause. Either side want to be heard as to bond?
Judge, we would just ask that, he has two friends that are trying to post the bond right now at $750, so we would just ask that it be left in place.
It's fine, Judge.
Pardon?
I'm fine with that, Your Honor.
Okay. Bond is set in the amount of $750. Anthony Smith?
Main jail.
Mr. Smith, you're here this morning charged with aggravated assault with a deadly weapon without intent to kill and resisting an officer with violence. I do find probable cause as to each of those offenses. State?
Your Honor, I'm going to be requesting a $10,000 bond on count one, $1,000 bond on count two, no victim contact. I am concerned based on the allegations that in the presence of a law enforcement officer, he threatened the victims at knife point. I would also note he has a history of domestic violence in Dade County in 2018. He had an arrest for battery. I have no disposition. In 2016, he was convicted of domestic violence battery. There was an additional count of aggravated assault. That charge was dropped. He also has a prior for strong arm robbery out of Dade County from 2011. Nothing further.
Would you like to be heard as to bond?
I would, Judge. He's lived here all of his life. He's 27 years old. He indicated that he does work some at the labor pool. He does have family members here that are going to try to help him post bond. They couldn't post anywhere near the bond that the state's asking for. What I would ask the court is if the court on count 1 would set bond at $3,500, on count 2 $1,000, a total of $4,500.
Okay, I do find probable cause as to each of the offenses on count 1. I'm going to set bond in the amount of $10,000. On count 2, bond is set in the amount of $1,000. There's absolutely no victim contact. And no weapons or firearms. Dontrell Anderson, or Dontre Anderson. Looks like this is a case where there was a warrant for illegal use of a credit card 2 times in 6 months. It's a felony case where there was a capias issued. It's a not in custody capias on that charge. I do find probable cause, what says the state with regard to bonds.
Nothing additional.
Okay. You want to be heard as to bond?
Judge, I can tell the court that he's lived here for 26 years, that he indicated he has no money. He works as a landscaper. He does have family members that are going to try to help him. He's not sure if they would be able to post a $1,000 bond. He wants me to ask the court if the court would consider RORing him. If the court's not inclined to do that, I would, if I can have 1 second.
It's like there's,
And if the court, I'm sorry, if the court's not inclined to do that, if the court would just leave the $1,000 bond.
it looks like there's a prior for grand theft in 2017.
Yeah, actually, he's on supervision for that, Your Honor. What I think, and the reason I was asking the bond to be kept in place is while he is on supervision, this allegedly was committed while that case was pending in Dade County, so.
Okay. So I'm going to leave bond in the amount of $1,000. Frederick O'Neill Mathis. Charged with possession of cocaine and attaching a registration or license plate not assigned. You find probable cause. Either side want to be heard as to bond?
I do, Judge. Judge, I can tell the court that he's lived here all of his life, that he indicated he has no money because they spent all the money on their gifts for Christmas. He currently works as a self-contractor through the city of Hollywood. He said that he has family that live here. Unfortunately, they're out of town at this point, so we really can't get a hold of them and call them and ask them to do anything. What we would be asking is if the court would consider RORing him at this point.
Your Honor, I wouldn't have an objection to pretrial with random testing, but I am not going to insist on monetary release.
Okay. I'll release him on his own recognizance to pretrial release. Standard pretrial. He is subject to random testing. And no alcohol or any other intoxicants while you're on pretrial release. That's a condition of your release. You understand, sir?
Yes, ma'am.
Okay.
Thank you.
Thank you, Judge.
Roberto Almi,
Medical loan.
Your Honor, the only request I would make,
pardon?
as you can see, he was arrested on the 18th. If the court could make a probable cause determination, he need not be present for that. I have no issue with him being reset for bond purposes.
That's fine.
Okay. I do find probable cause, but I need to put on here,
I think if you just check off PC but put reset for bond, that
okay,
would suffice.
because this paperwork had some comments from the previous, so. I'm probable cause, and I'll put on here reset for bond purposes. Johnny Fred Pugh.
North Broward refused.
Your Honor, I would ask if the court would be inclined to address this. This is actually to his benefit. I've been advising the ASAs in court all weekend. I remember from reviewing this on Friday, I think the officer might have misbooked count 1, where he's charged with burglary with a battery. There is no allegation of an assault and or battery in the probable cause affidavit unless I missed it. I don't believe I did though, which would make him eligible, constitutionally eligible for bond.
Do you have a recommendation as to bond? I mean, because there's some previous paperwork indicating there was a medical reset, so that they have notes all over the paperwork, so.
I do, Your Honor. On count 1, it would be 5,000, 2,500 on 2, considering that he also has a violation of probation hold for strong arm robbery.
That supposedly was being heard this morning at 9 o'clock,
And I imagine they'll probably reset that for tomorrow.
because he's a medical reset?
Because, well, I imagine if he refused, then he definitely didn't bring him to, before Judge Garcia would. I mean,
Okay, so
ultimately, I don't-
there has not been a probable cause finding in this case?
No.
Okay, because there's notes on here. And it doesn't show, oh, it does show a no bond, okay, on the violation of probation. Okay, I do find probable cause as to a burglary on count 1. And in light of that, I would set bond in the amount of $5,000. Count 2, burglary. Set bond in the amount of $5,000. So it's a total of $10,000. And I do find probable cause. Okay, Wesley Demostine?
Medical reset.
And again, Your Honor, I believe this will be his 3rd reset, so I would just ask if the court would be inclined to make a determination one way or the other for probable cause. I have no objection to being reset for bond.
Okay, I do find probable cause, and I'll just say reset for purpose of setting bond. Reset it for setting bond. Okay, Peter Philip Simone.
Medical reset.
Same request, Judge.
Looks like it's a first reset, though, is it?
Is it? I thought it was.
Oh, no, there's been a previous one.
Yeah.
What are you asking for bond? I do find, oh, you
Oh,
wanted me
no,
to reset it for
I'm
bond.
fine with him coming back for bond.
I do find probable cause.
Is this guy Lisa? Simone? Okay, thanks.
Okay, and then I have Corey Irvin.
Main Jail. Judge, he indicated he was here yesterday, Mr. Irvin. I don't know what the situation is, if this is that charge.
Apparently we're here only for count one
Okay.
through 6. He was here yesterday on a different 7 through 12. So today we're here, the charges are petty theft, a third or subsequent offense, and then violation of probation for 1, 2, 3 separate cases where he's being held no bond. There's 2 counts of petty theft, third or subsequent. I do find probable cause as to those. What says the state as to bond on those? It's currently
Right.
set at $750.
Considering he has multiple no bond holds, I'm not asking for any.
Okay, so I'll leave bond set in the amount of $750 on each of the 2 petty theft, third or subsequent offenses, and no bond holds on the violations of probation.
Your Honor, the main jail would like to know what time we're starting.
You know, just to let you know.
It's 12 o'clock. One, two, three. These ones I just got. Can we do them now?
You wanna pull?
Oh, we have 7.
I just asked if we could, at least, if we
Want
could
to
start
start
at
at
1.
1:30 instead of 1, or
If we could start at 1, that'd be great.
want to start at 1?
Yeah, that's fine with me.
Okay.
One's good.
1 o'clock.
Okay. All right, we'll see you all at 1 o'clock.
Thanks, Judge.
Yeah,
Okay.
the afternoon docket's 3 pages, Mike, 3 cases.
Perfect.